Welcome to TNR Live. I'm Matt Ford, staff writer at the New Republic, where I cover law, democracy, and the courts. Thank you for joining us today for the final installment of our three-part Supreme Court Watch series. Throughout the month of June, TNR is bringing you breakdowns and analysis of key opinions and what they mean for our democracy and for you. The court released more opinions on this morning, but we recorded this on Wednesday afternoon. That way our panelists could take part, and that way we didn't have to worry about me missing any deadlines. We wanted to ensure that we had enough time to really dig in with our guests today. We'll be talking about opinions handed down over the last few months that may have flown under the radar, cases that didn't receive the headlines they should have, but were important nonetheless. We're trying to use them to draw whatever conclusions we can about the legacy of the court's term. Joining us today is Rebecca Nagle. She's a writer and advocate and a citizen of the Cherokee Nation. She is the host of the award-winning This Land podcast. In its second season, Rebecca and her team tell the story behind the challenges to the Indian Child Welfare Act and the Burkeen v. Holland case that we'll dive into today. Steve Vladeck is a professor of law at the University of Texas. He's a nationally recognized expert on federal courts and constitutional law, a CNN legal analyst, and the author of The Shadow Docket, How the Supreme Court Uses Stealth Rulings to Amass Power and Undermine the Republic. Kirti Datla is Director of Strategic Legal Advocacy at Earthjustice, a nonprofit public interest and environmental law organization. Kirti has worked in the Supreme Court and appellate practice group at Hogan Lovells and clerked at all levels of the federal judiciary, including for Justice Sonia Sotomayor. Rebecca, I'll start with you. What is the Burkeen case? What is this dispute over the Indian Child Welfare Act? And what does this tell us about the court's ruling and about tribal sovereignty?
Absolutely. So the Burkeen case was a challenge to the constitutionality of a law called the Indian Child Welfare Act, or a lot of people call it ICWA for short. It was passed in 1978 after Congress recognized between a quarter and a third of all Native kids had been removed from their families and tribes. And basically, ICWA makes it harder to take a Native kid away from their family and away from their indigenous nation. The Burkeens are a white evangelical couple from the suburbs of Dallas that wanted to adopt a Native American toddler that they had been fostering. They actually did adopt that child. But before the adoption was final, they filed a preemptive lawsuit in federal court saying that the Indian Child Welfare Act violated their constitutional rights because it was racial discrimination. So basically, it treated them unfairly because they are not Native. The state of Texas joined the lawsuit and kind of made a states' rights argument that fell into a bunch of different, sometimes overlapping buckets, but basically together they also, in addition to the equal protection argument, they also argued that Congress doesn't have the power to pass a law like ICWA in the first place. The reason that that lawsuit was a really big threat to tribes and tribal sovereignty is that those two arguments have really broad implications in the arena of federal Indian law. So a whole host of laws treat Native Americans differently, and it's not based on a racial classification. It's actually a political classification that exists because of the unique relationship between indigenous nations and the US government. And, you know, Congress has generally been seen to have a lot of authority in the arena of federal Indian affairs because of that unique relationship that goes back to things like the Commerce Clause and the treaty powers. And so the fear was that this case was going to be kind of like a bomb going off in the arena of tribal sovereignty, and that it would have all of these other implications and impacts. And then the long and short of the Supreme Court decision is that in a 7-2 opinion written by Justice Amy Coney Barrett, the plaintiffs in Texas lost on absolutely all grounds. So on some of the grounds, they lost on the merits, and then on some other grounds, the Supreme Court said that they didn't have standing. And so, you know, I think another important thing to note about the case is that, you know, it didn't fall out of the sky. It didn't arise organically from a custody dispute. There has been a small group of special interests that have been attacking the Indian Child Welfare Act in the past decade. This law has been challenged nearly as many times as the Affordable Care Act. And so this was sort of their best attempt, their best effort, and their closest attempt to, you know, harm tribal sovereignty by taking down ICWA, and it didn't work. So that was a huge sigh of relief for tribal leaders and for Native advocates.
Tribal sovereignty's had sort of a back and forth record at the court recently with the decisions out of Oklahoma, and now the decision with the Navajo Nation in Arizona. Where do you think the court currently stands on tribal sovereignty?
Yeah, that's a big question. I mean, and I think back and forth is absolutely the way to characterize it. We had a decision like McGirt, and then we had Castro, and then we had, the Brackeen case. And then even within, even on the same day, there was a case about sovereign immunity that the tribe lost an 8-1 decision the same day that Brackeen came out. And so, I think a lot of times people think that tribal sovereignty maybe follows political lines, but I think it's often more complicated than that. So you have some justices who, when it comes to federal Indian law, are really wanting to follow the text of the law and what the Constitution says. Like Justice Gorsuch. And then you have justices that seem kind of skeptical fundamentally about, whether or not the existence of Indigenous nations is constitutional, like Justice Thomas. And then you also have a lot of justices that I think just sort of struggle with federal Indian law. It's a very unique area of the law. It's not taught well in law schools. It's getting better, but there's still a lot of work to do. And so I think sometimes the sort of roller coaster that tribes are on in not just the Supreme Court, but in federal courts, I think a lot of that has to do also with ignorance and people, just not really understanding this area of the law. So we'll have to see, what comes next. But, it would have been a very, very radical decision for the Supreme Court to overturn ICWA on the grounds that the plaintiffs were arguing. It literally would have gone against, a couple hundred years of precedent, which, Coney Barrett sort of wryly pointed out in her majority opinion. And so, I think that's another important context for this case. It's not necessarily a victory for tribal sovereignty. It's really just maintaining the status quo.
And where does that fit within the sort of the broader context of how the tribes have viewed the court? Yeah, as you mentioned, this is a long history. It's a complicated history. Where does the court stand among its predecessors right now in sort of weighing the role that tribes play in our constitutional structure?
Yeah, if you take the long view, tribes have lost the majority of cases that have been brought in front of the Supreme Court. And so if you look at about the past 20 years, and this doesn't include the past few years, it was 2/3 of cases. So tribes have not fared very well. And one of the things that's interesting about the last 50 years or so is that, as Native people built more political power within the United States, while congressional policy isn't perfect, we are having policies out of Congress that tend to do more good than harm. But then at the same time, some of the large setbacks when it comes to civil jurisdiction, criminal jurisdiction, water rights in the Navajo case, some of those large setbacks are coming from the Supreme Court. And so, I think that there's a lot of work to do. And I think too, a lot of the times when tribes lose at the Supreme Court, I mean, the very short explanation of why that happened is because the court didn't follow the law and kind of made up a new rule, legislated from the bench, didn't really respect what Congress had said in writing. And so, we saw that in the Castro opinion just last term. And so I think, as the broader country is starting to have these conversations of like, well, what is the role of the Supreme Court really? And what is like the separation of powers in our democracy? I think there's a lot to learn from tribes because we've sort of been bearing we're not the only group by far, but we've been bearing the bad end of that for a while now.
One of the most commented upon aspects of these cases, at least for the broader public, is the role that Justice Gorsuch plays in them. He's really surprised a lot of observers by being, I guess, for lack of a better word, passionate. We usually don't use that word about judges on cases, but somebody who's very passionate about these cases. Why do you think that is? Was this a surprise to tribal governments?
I don't think it was a surprise to people who were paying attention. When Gorsuch was appointed by Trump, he received the endorsement of the National Congress of American Indians. So he came from the 10th Circuit, which is a circuit that has a lot of tribes and tribal land in it. So, I mean, again, like I was saying before, one of the biggest barriers in these cases is ignorance. And so he was knowledgeable. I think what he has done that I think is unique and special is that when he looks at whether it's a treaty or congressional policy, in his opinions and his dissents and in his concurring opinions, he's writing about what these policies meant to Native people, which you don't see judges do. So like in the McGirt opinion, he taught, like, Oklahoma was like, well, how can all these people wake up on a reservation? That's not what they thought. And he has a line in there that's like, well, if you talk to, like, the members of the Creek Nation from 1830s, they would be surprised to find all these non-native people on their land that was promised to them. And so there's this way that he's trying to, which, you're supposed to do, like, treaties are kind of like contracts, you're supposed to understand the contract from, like, both sides, right? And actually interpret it. I mean, this is like getting into the weeds, but whatever, interpret it to, like, the weaker party's understanding. But I think Justice Gorsuch is really trying to understand and speak to and put into the record what these laws and these policies really mean from an Indigenous perspective. I think he did that with his concurring opinion in Brackeen. He talked for a long time about the history of family separation and child removal in Native communities, and why the Indian Child Welfare Act is important in the first place. And so I think that's a welcome development. He is joined by some other justices that are very knowledgeable, like Justice Sotomayor, who are starting to ask questions and making it harder for these sort of wackadoodle opinions that really don't have a lot of legal grounding, like Castro. It makes it harder for the court to get away with that.
One of the other aspects of the law that's received a lot of attention in recent years has been environmental cases. We saw a major decision last year about the Clean Air Act and how power plants could regulate their carbon emissions, how the federal government can do it. This year, we had another major one, this time on the Clean Water Act. Kirti, I want to bring you in now and ask about Sackett v. EPA. This is a case that had broad implications for American water policy, but it seems to hinge on some very technical definitions about wetlands. What can you tell us about that?
Sure, yeah. I guess this case could seem technical, but it actually boils down to a pretty simple debate. The case is about sort of the jurisdictional reach of the Clean Water Act, which is a 1972 statute that has its roots in many older statutes, but was sort of comprehensively rewritten then. And various provisions of the act apply if the waters at issue meet the statutory definition of navigable waters, which the statute in turn then defines as waters of the United States. And the debate in this case, and what the federal government has been doing since the Clean Water Act was enacted, is about how to read that phrase, what that phrase means. And specifically in this case, the issue was whether and to what extent that phrase covers wetlands. And that's important for many reasons, but at a very basic level, wetlands provide protection for the kind of waters that you would definitely think are part of and covered by the Clean Water Act: rivers, streams, lakes, things like that. They hold back water, so they're really important for flood control. They filter pollutants, so they're important for maintaining the health of those waterways, and they serve a bunch of other important functions as well. Somewhat interestingly, everybody in the case agrees that some wetlands have to be covered by the Clean Water Act, and that's because in a separate provision, Congress sort of allocated responsibility for implementing the Act's permitting programs between the federal government and the state. And in doing so, it said, the states have control over the permitting programs except for what the federal government has control over, and that includes wetlands adjacent to traditional navigable waters. And so there's no reason to carve out the program in that way unless the overall jurisdiction, which again is defined by the phrase waters of the United States, includes those kinds of wetlands. So at that point, the case, once everybody kind of agreed on that baseline, became about what adjacent wetlands means. And the debate between, technically it's a majority and a concurrence, but the concurrence, they're sort of disagreeing fundamentally over what those words mean. So you can kind of think of it like a majority and a dissent in sort of common parlance in terms of they are disagreeing about how to read the statute. And the majority, written by Justice Alito, says, the word adjacent can mean nearby, it can mean sort of contiguous to, and we are going to say that it means visually indistinguishable from due to a continuous surface connection to a lake, a river, a stream. And the reason that Justice Alito gave for that is that in his view, because wetlands are a subset of waters of the United States, they must have all the characteristics of waters of the United States. So in his view, that means because rivers, lakes, and streams are waters of the United States, wetlands must be sort of indistinguishable from those to be a subcategory of them. And if that seems at all confusing to anyone listening, that really is the best summation of the logic of Justice Alito's opinion that I could give. The folks who disagreed with that interpretation, the main opinion is a concurrence written by Justice Kavanaugh, joined by Justices Sotomayor, Kagan, and Jackson. And Justice Kavanaugh says, pretty basically that adjacent doesn't mean contiguous to, doesn't mean adjoining, and that it can mean something like closer to or nearby. And then he relies on the continuous interpretation of the Clean Water Act by every administration since the issue came up to say, at the very least, it has to cover wetlands that meet Justice Alito's definition, but also wetlands that are connected in some other way and only separated by something like a road that was built or a berm, which is sort of like sediment that gets deposited over time in between a wetland and a river, wetland, or a lake. So the debate is really about does it cover wetlands that are separated by a sort of artificial or natural barrier? And I think that's helpful to keep in mind if we are going to get into sort of the reasons why the opinions come out differently and the stakes that the majority seems to think were at issue in this case versus the concurrences.
And when we talk about the differences between adjoining and adjacent, it may seem technical, but this has pretty broad implications for federal water policy, for environmental protection. What sort of things could be affected by this decision?
So one, I guess, interpretation of the Clean Water Act that all of the justices decided was not the correct interpretation of the Clean Water Act is a test that had been basically broadly applied by all of the courts of appeals and the government in its most recent regulation, which was called the significant nexus test. And that comes from one of the opinions in the Supreme Court's case the last time it considered this issue, which was in 2006 when it couldn't reach a majority opinion. And so if you think about the difference between a sort of significant nexus test, which is basically like wetlands are covered if they significantly affect the health or integrity of river, lake, or stream. And that was grounded in the idea that Congress expressly enacted a purpose provision in the Clean Water Act and said that was its purpose, to protect the scientific, chemical, and biological integrity of these waters. And the difference between the significant nexus test and so basically the prior coverage of the Act before Sackett and after Sackett is pretty big. It's hundreds of millions, millions and millions of acres of wetlands that are now not covered by the Clean Water Act. And there's some hint in the briefing that states will just step in and take over. And so there's nothing to worry about here. But in reality, almost half of states have provisions in state law that say that their state programs can't go further than the federal statutory definition. And so they basically enacted a ceiling that makes it, unless there are changes to the law, makes it so that states won't in fact step in and cover and protect those wetlands. So the impact of the decision is quite significant in terms of on-the-ground coverage of the Clean Water Act to wetlands.
One of the most striking things about it for me was that there seemed to be not only a divide between Justice Alito and the court's liberal members, but also between him and Kavanaugh on sort of the textual reading of the statute, to the point that the liberal justice even called out Alito, saying that this was almost disingenuous the way he framed it. What do you think that says about the broader ideological divide between the court over how they read federal laws and what that could mean for the rest of us?
One way to think about it is, if you strip this decision from sort of any context and you just look at it in sort of an academic sense, like Justice Alito has one view of the word adjacent, Justice Kavanaugh has a different view, and that's all there is to it. It's sort of, maybe it's a dueling dictionaries kind of debate. I think the other way to think about it is to just read the opinions for what they're worth. If you read Justice Alito's opinion, there's a clear sense of both disdain for the particular program of the Clean Water Act that's at issue here, which is about kind of dumping dredge and fill materials. So if you think of something like mining and excavating a bunch of really significant portions of the earth and then dumping it into a wetland, that's kind of what this program is about. And the opinion that Justice Alito refers to, moving dirt. So it really minimizes the benefits of this statute and what it is designed to protect and has protected. And on the other hand, describes the costs of the statute as, crushing, and highlights the specter of criminal enforcement, despite the lack of any real evidence that that's actually historically a problem or even theoretically a problem. And really hones in on what he thinks is a sort of fundamental unfairness that the statute imposes on people who own property and might want to fill in a wetland on their property, I guess. And Justice Kavanaugh just doesn't seem to have that concern based on his description of the sort of continuous interpretation of the statute across every administration to consider the question. So, it seems like you have one set of justices that think there's some real unfairness or potential for unfairness that needs to be corrected and reined in here. And you have another set of justices who think in reality, the statute just doesn't work that way in practice. Those consequences won't occur. And I think the way you see this most clearly is actually in Justice Kagan's concurring opinion, where she addresses sort of the moves, the interpretive moves that Justice Alito makes in his opinion to justify his interpretation of the Clean Water Act, sort of imposing a new, or at least newly reformulated, clear statement rule akin to what happened in West Virginia versus EPA, which is the Clean Air Act case you referenced, Matt, and also invoking sort of a rule of interpretation that applies in the criminal context in terms of vagueness and lenity. And all of that, Justice Kagan says, is really motivated by the folks who joined Justice Alito's opinions, real discomfort with how the law was written and a desire to rein it in. And she says, I think they've appointed themselves as the sort of arbiters of national environmental policy, and that that's not how things should work. So I think those are kind of the bigger stakes. And of course, it's about what the word adjacent means. And that, of course, is an important question that has real world consequences in terms of clean water. But it's also about this broader debate that seems to be going on between the justices about the role of the courts in policing what the executive branch does, and the role of Congress in being able to address certain problems like the protection of clean water. But I definitely love to see if the other folks on the panel have views on that as well.
Yeah, I was hoping actually to ask Steve, because I know he deals with this question of the justices' various differences on textualism, on originalism, on how they read statutes and the Constitution. What do you think this tells us about the changing nature of the court, Steve?
That the six conservatives are not of a piece on these textual questions. Something I think we already had a pretty good sense of from prior terms. But also, Matt, I mean, I think Kirti is right that it really does underscore one of the central critiques of textualism, which is that even those who are avowed textualists can look at the same text and come up with different interpretations, which makes it hard to believe that textualism provides one true answer to the questions it purports to settle. So, I think in that respect, Sackett is just the latest in a line of rulings that probably go into this camp of whether you want to call it faint-hearted textualism, whether you want to call it sort of revealing inconsistent textualism, just, hard though maybe to believe textualism is not a sort of get out of analysis free card when it comes to statutory interpretation. I think Kirti is right about the ways in which the majority opinion in Sackett leaves more than a little to be desired on that front.
Steve, you've literally written the book on the Shadow Docket. Can you walk us through what that means, how the court's handling of emergency appeals is affecting its role doctrinally in these cases?
Well, I mean, one of the tricky parts about how much the court has used unsigned, unexplained orders in the last couple of years is that it doesn't necessarily move the doctrine at all. And indeed, ironically, as we've seen this term, sometimes when a case gets back to the court on the merits, the justices end up in a different place than they were at the emergency application stage. So just to sort of take two quick examples of this, we've seen in the last couple of weeks, first in the Alabama redistricting case, which I know you guys have already talked about in one of your prior panels. That case started with a grant of emergency relief from the court in February 2022, one that, there was no majority opinion supporting, there was no rationale. And the only writing in support of that stay by Justice Kavanaugh went out of its way to say, we are not saying anything about the merits. This is not about the merits. And yet, right, once that ruling goes into effect, it directly affects congressional maps in at least 3 states, Alabama, Louisiana, and Georgia. You can tell a pretty easy story about how it also affected Ohio and South Carolina. So as many as 5 to 7 seats in the House that end up being safe Republican seats only because of an unexplained, unsigned order from the Supreme Court. And Matt, when that case comes back on the merits docket, we know that the court ruled 5-4 that the maps actually were unlawful, without ever trying to justify why the court had allowed them to be used anyway. To similar effect, we saw just last week in U.S. versus Texas, the case about the Biden administration's immigration enforcement priorities. This is following a pattern, and Rebecca's encountered this, of course, in Brackeen, where Texas seeks a nationwide injunction, like Texas forum shops to a friendly district judge in Texas and obtains some kind of, I might say, outlier type of relief. And then, the government goes to the Fifth Circuit for a stay. The Fifth Circuit denies a stay. Government goes to the Supreme Court for a stay. Supreme Court denies a stay. But then 2 years later, when the case comes back on the merits, the court sides with the Biden administration. That happened last term with the Remain in Mexico case, where the Biden administration had tried to rescind this deeply controversial Trump-era asylum policy. It happened this term with the immigration enforcement priorities. And so, Matt, when we're looking at sort of the cases that get less attention and less visibility, one of the real alarming patterns that I think you see if you look at the shadow docket is that one of the best defenses that you hear from the court's defenders, from Justice Alito himself, right, when folks are trying to defend how aggressive the court has been in granting emergency relief and stepping in at ever earlier phases of litigation, is that the justices are simply previewing the merits, that they're allowed to sort of speed up the litigation if they know how they're going to rule. Well, lo and behold, it turns out they don't know how they're going to rule, and they're not very good at predicting what they're going to do, which just calls into further question the propriety of all the interventions that we're seeing at the emergency relief stage. Now, I will say, just one last note on that, the court has been a little less aggressive this term when it comes to emergency relief. As we hit the end of June, there's only been a total of 5 grants of emergency relief all term. And 2 of those were not remotely contentious. One was an Oklahoma execution where the state itself agreed to the stay. So, it's possible, Matt, that actually we're seeing a bit of moderation in at least some of the justices' behavior when it comes to emergency relief. But all the while, we're seeing merits decisions calling into question earlier interventions by the justices last term, 2 terms, 3 terms ago, that I think really reinforce the problems with how the court at least had been behaving.
I'm glad you mentioned that shift, because you had a post on Twitter the other day that caught my eye, noticing that decline. Do you think that's reflective of growing criticism of the court on this practice?
I think surely part of it is. I think, you can look at the data and see Justices Kavanaugh and Barrett especially voting for emergency relief less often than they had been as recently as 18 months ago. You can see, for example, in the Mifepristone case, when Justice Alito is, calling his colleagues hypocrites, one of the people he accuses of being a hypocrite is Justice Barrett. Which is interesting. So I think that's part of it. Whether, Matt, that's a response to public criticism, there have been some pretty sharp internal criticisms from Justice Kagan. Even Chief Justice Roberts signed on to a Kagan dissent in a clean water case from April 2022, where the court issued an unsigned, unexplained 5-4 order that put back into effect a controversial Trump-era pollution rule. So I think, yeah, Matt, there's probably been some of this as a response to public pressure. I think you could also say, now that the COVID emergency has formally, if not practically expired, that's taken some pressure off of the shadow docket. We're seeing maybe fewer of the types of applications that the court might have granted last term. But, we saw this term. I know it's easy to forget because there's been so much going on. The court refusing to grant emergency relief to President Trump. to Senator Graham, right, to Kelly Ward in one of those Arizona cases. In the West Virginia transgender sports case, the court denied an application for emergency relief over a dissent from Justice Alito. So, maybe there is a bit of a silver lining here that at least I don't want to say the middle of the court, but the median of the court is responsive to some of this public pressure and pushback. And maybe that augurs well, at least for some of this institutional behavior going forward. One other feature I think that we've seen on the shadow docket this term is the court pushing more cases from the shadow docket to the merits docket. The student loan cases, which may have come out by the time people are watching this, are a good example of that. Rather than decide those through emergency applications, the court kicked those to plenary review. So I think that's a helpful development, Matt. It doesn't get at the core problem, which is just how much earlier the court is getting involved in disputes, how much earlier in the litigation, how much less of a record, how much more sort of hypothetical some of the questions are. And I think that's a problem that is going to come through as much in the sort of lower profile cases the court decides this term as in the high profile ones.
Over the last few weeks, we've seen a few cases where conservative litigants, conservative states, and conservative legal activists have brought big cases before the court on things like immigration, on things like the voting rights, and they've seen themselves fall short. Is this a case of the court shifting doctrinally, do you think? Or is it something about overreach on the part of these litigants?
So I think there's actually a growing disconnect between the aggressiveness of conservative litigants, of conservative-led states, of conservative federal appeals courts, including the one I live in, and the Supreme Court. And, if we don't count the student loan case, because that's actually cert before judgment to a district court, not to the Fifth Circuit, the Fifth Circuit's going to end this term having had 6 of its 8 decisions that went up on the merits reversed or vacated. And, that's not a random array of cases. Those are ideologically charged cases like Burkeen that, Rebecca talked about before, like U.S. versus Texas, Reed versus Gertz. Remember, it was the Fifth Circuit's refusal to block Judge Kaczmarek's mifepristone ruling that actually forced the Supreme Court to step in. And so I do think that there is a story here about lower courts getting out over their skis when it comes to accepting radical, novel arguments from red states and conservative plaintiffs and having the Supreme Court rein them in. The trickier part is that in the past, Matt, when we've seen this, the court has actually gone out of its way to chastise the lower courts when it's been in the other direction. So, there was a period of time not so long ago where the court would regularly chastise the Ninth Circuit or the Sixth Circuit for being too solicitous of prisoners' claims or of civil rights plaintiffs' claims. Even as the Fifth Circuit's having such a bad term, even as Texas, which is 0 for 4 as a litigant this term, is having such a bad term, no one's saying anything about it. And so I think the real question is, are these lower courts, is the Fifth Circuit going to get the message that actually they don't have the votes at the Supreme Court, or are they just going to keep pushing the envelope because the worst thing that happens is they lose, the decision gets reversed, but no one gets their wrist slapped. I think that's something I think we'll have to watch for going forward. But I mean, I think, no matter what happened this morning or in the decisions that are still to come, tomorrow, this has been actually a really interesting term for the median of the court, by which I think, the Chief, Barrett, and Kavanaugh, signaling in lots of cases, big and small, that they are not as far out there as a lot of judges on lower courts and conservative plaintiffs both are and want them to be. I think the question is anyone going to take that message and do anything about it?
Hey, Matt, could I ask Rebecca a question that's related to this? Thank you. Thanks. I'm just, Rebecca, I'm so curious, during the argument in Brackeen, it was sort of very clear there was some maybe annoyance with the way that Texas has presented its argument, and the opinion itself sort of chastises Texas a little bit for not giving the court what it might need to agree with them. And then one thing that stood out to me about the opinion that I would love to know what you think, or if you talk to folks who have views about it, is the way the court wrote its decision. So it said we declined to disagree with the Fifth Circuit's decision or judgment that ICWA doesn't violate Congress's powers, rather than like we wholeheartedly agree that that it doesn't violate it. So I'm just curious whether you think if Texas had done a better job or someone else comes along and does a better job, there's still some risk there.
Yeah. So a couple of things. Yeah, there were some I mean, as humorous as the Supreme Court gets, right? There were some like funny moments in oral arguments. So there was this like one moment where I think Kagan kind of like needled the Solicitor General of Texas and was like, oh, like all these things that you don't like about it, but they're just atmosphere, right? And he like admits it. And then you see Coney Barrett kind of like she talks about how you know, like the constitutional powers of like Congress like don't just come from atmosphere, but like come from the Constitution and precedent. And so there's this way that they were kind of almost like, I mean, again, like as close as the Supreme Court gets to like mocking something, like there was a little bit of that there. And I do think that like Barrett's opinion was kind of just like, get the hell out of here, like who are you kidding? You know, like one of the things she writes is like, you know, the plaintiffs in Texas pretend like, you know, they're starting with a clean slate, but after like 200 years, like the slate's not clean, you know? And then I think I hope I'm understanding your question right. You're kind of asking about like how they decided some of this stuff on like standing versus the merits, if like that invites like more people to bring cases, because they invited like because they decided the equal protection on the standing.
Yeah, I think I'm more, there's just this, the opinion doesn't say ICWA like is, you know, valid under Congress's you know, various powers with relation to the tribes. It says we decline to disturb the Fifth Circuit's conclusion that ICWA is valid, and that just struck me as like pretty. I think I have it. I think I've seen that happen like once before. So I was just curious whether I'm totally overreading it, and or whether you think there's something there.
That's interesting. I mean, I felt like I guess I didn't extrapolate that much out of that section of the opinion, because I feel like the wording, you know, it's like Barrett kind of starts with like an entire explanation of like the treaty power, the Commerce Clause, the you know, she talks about the trust relationship. I mean, it sort of almost reads like a federal Indian law like textbook you would get in like your first day of class at law school. And so she's just kind of like, here are like the basic things. And so I felt like she gave like or the majority gave like a pretty like full-throated, like Congress has the authority to pass a law like ICWA. And then she kind of, because I also felt like after she gave that like broad explanation, she went one by one through their arguments that like, because it's family law, the whole anti-commandeering stuff, that like, nah, like none of this stuff like makes sense, you know, even like the record keeping. But I have heard a lot of people say like that they're worried that the equal protection will like come back around. And I just wanted to speak to it like really quickly, because I think there's been some concern, especially because like if for folks who don't know, that whole argument I talked about like really early on about like the plaintiffs saying like we were discriminated against, this violates the Constitution, ICWA is racial discrimination. The Supreme Court didn't actually say whether or not it is. They just said the plaintiffs don't have standing in this case to bring that argument. And then Kavanaugh wrote like a very short concurring opinion that he agrees that the plaintiffs don't have standing, but he thinks that there are like equal protection concerns. And I've seen a lot of people be like, oh crap, they're just going to bring another case. And I think that they're going to try, but I think that they have been trying, like this little anti-ICWA coalition has been trying to get a case back in front of the Supreme Court since Baby Girl a decade ago. And most of those cases haven't gone very far because they've either become moot or like courts have thrown them out because the plaintiffs don't have standing. And so this was like their best shot and it didn't work. And so I think that that's a bigger setback for the anti-ICWA advocates than I think some people. I think it is an invitation to bring another case, but I think that they're going to have a really hard time doing that. And I also think that the standing, like the, I mean, you know, I'm sure you guys are like, have reported on this a lot, where there's just like, it was like a wonky case that like made no sense. You know, it's like they actually, like the plaintiffs won custody, all the adoptions were finalized, like it didn't make sense as a lawsuit. And so I think it's a good thing that they lost on the standing, because, you know, it makes it harder for people to, sue because they just don't like something, like you're not supposed to be able to like strike down a federal law because you don't like it. It's like you're supposed to have a real live controversy. And so I think the Supreme Court setting that boundary is good in this case.
Well, and that's why I think Burkine really dovetails with US versus Texas, because I think there's a mentality among some that like, well, if Texas can't bring these lawsuits, someone else will. And the answer is actually no. Right, that like, part of what's happened in the Fifth Circuit is that the Fifth Circuit has taken such an expansive approach to state standing specifically that Texas and Louisiana are able to bring suits in contexts where there's really no other obvious plaintiff. And where, they're challenging immigration policies that actually only produce benefits, where it's really hard to find a private person who's been in any way aggrieved by the policy. And so I actually think that like this is where, despite whatever headlines we get out of affirmative action and student loans, and those are going to be big headlines, and 303 creative, I actually think there's something meaningful in the fact that Barrett writes Burkine and Kavanaugh writes US versus Texas. Had it been Justice Kagan, would she have taken a couple of more shots at Texas? Probably. She also did in the US versus Texas argument. There's one point in that argument where Texas's Solicitor General said, well, the district court found, and she cuts him off and says, well, you picked the district judge, didn't you? As if like, maybe we shouldn't be so like, weighing on the district judge. So, there are lawsuits that really are not capable of being brought by anyone other than states under these capacious views of state standing. It's possible that in Nebraska versus Biden, the state student loan case, the court's going to nevertheless allow that case to go forward. It's possible the court actually says, no standing here either. Either way, right, I think there's going to be a message there about lower courts being too willing to accept, Rebecca, theories of standing that just don't make sense. And that allow, that make it easier for courts to reach what are divisive, contentious, but hypothetical legal questions. And I think, hopefully that's a lesson that makes its way out of this term amidst all the other headlines.
That's a good segue to bring in a question from our audience. We had them pre-submit them in advance for this. Josiah asked, any signs of significant breaks, disagreements, or divergences among the 6 conservative, quote unquote, justices? And I think that we're really touching upon that here, which is the justices are struggling not just on a merits level, but also on a procedural level, how to wrestle with some of these cases. Kirti, how does that inform your approach to the environmental aspect of this?
Yeah, I think there are a group of litigants that generally just try and avoid being before the Supreme Court, and we're probably one of them. So that's the big picture strategy, which doesn't take a genius, I think. But I do think some of the disagreement that comes across between the conservative justices in the majority, along with what's already been touched on in terms of how to use the shadow docket, is sort of how fast. I think there's probably overall agreement on the kind of general direction, but I think there's real disagreement, and Brackeen's an example of you can't just come to us and tell us to do something. You have to give us a way to do it, is sort of one theme of that argument. And you see in a bunch of cases sort of concurring opinions from justices saying, here's what parties or litigants or lower courts need to do to get us to where we're willing to go, and then some justices are willing to go there already. So United States versus Texas is an example where Justice Gorsuch sort of calls out this sort of somewhat nerdy question of administrative law remedies and what courts can do when the government acts unlawfully. And his opinion says, very expressly, lower courts need to start a debate and flesh out the arguments on this issue for us because I want to consider it. Whereas other justices have firmer views on the availability of that specific remedy. And then, you just see all sorts of separate writings kind of laying out a vision for where the law should go, and other justices not joining them, indicating they're not ready to go there quite yet. So I think that's, those concurring opinions are always really interesting to watch for sort of where those trends are, but also signs about which justices are less willing to move as fast as others. And I think it's just sort of fairly clear that Justices Kavanaugh and Barrett are not willing to go as fast as Justices Alito, Gorsuch, and Thomas.
Yeah, Steve Mazie wrote a piece for The Economist 2 years ago. It was titled "The 333 Court," and he got absolutely pilloried for it because folks, I think folks misunderstood to a degree what Steve was saying. But I think we have a 333 court. That does not mean that the three justices who are between the two poles are moderates. It just means they're in the middle. And as is true of any median in a large group, they're going to be the ones who have control over the direction more than the groups to the polls. And I think last term we lost a little bit of sight of that because all of the big headline cases had the conservatives basically in lockstep, at least 5 of them, if not all 6 of them. But I think we're seeing a little bit more this term, the meaningful daylight on, Kirti's exactly right, on speed, on timing, on, sort of agenda setting between, the median 3, right, and the far right 3. And I think, that's something that folks should not lose sight of. We should not read too much into it. There was like a headline in the New York Times yesterday about how the court's now moderate. I think that's kind of ridiculous. But the court is a they, not an it, and that's true of the conservative majority as much as it's true of the Democratic appointees.
Okay, Rebecca, one thing that struck me, and I think the others can also weigh in on this, is an unusual thing, or maybe not so unusual thing we saw with Justice Kavanaugh writing concurrences, where he seems to agree with the majority on most things, but also feels the need to set aside his own views. What conclusions did you draw from that? And is he signaling to future litigants, to future courts? What's going on there?
Yeah, so, and I mentioned this a little bit before, but in the Brackeen opinion, he joined the majority with Coney Barrett. It was 7-2. And it was actually really kind of complicated the way, like the opinion's actually really short. It's like 34 pages. And then there's like another 100 pages of like other things other justices had to add. So Kavanaugh wrote a very short concurring opinion that he agrees that the plaintiffs don't have standing in this case, but he does think the law raises equal protection claims. I think that was like easy to see at oral arguments. He was asking a lot of cases that were even kind of like a little inflammatory. So he like asked a question that's like, well, we couldn't just pass a law that only like white people could adopt white children. Or he was like, could the federal government mandate that, Native Americans get into colleges? And, like sort of like all, and Alito and even the Chief Justice joined in that a little bit of sort of these like hypotheticals that did sort of recast that political relationship between indigenous nations and the US federal government as some type of racial preference. And so I think the fear of a lot of people sort of watching Kavanaugh's concurring opinion and then seeing that instead of deciding it on the merits, the Supreme Court decided it on the standing issue, that left a lot of people, fear that, okay, well, they're just going to, find another case. And, I talked a little bit before about why I think it will be difficult for them to find a case that has standing, especially after they couldn't do it in this case. But I think the other thing to note about Kavanaugh's concurring opinion is that he read it alone and nobody else signed on to it. And you don't get to a majority that way. And even if maybe you could kind of infer into like Alito and Thomas's dissent that they would join onto it, that's still only 3 votes. So yeah, but I think that was interesting. I mean, I think that's the other thing. I've mostly reported sort of with like blinders on this one case, but from like the reading I do on other cases, it does seem like that was one of the things that happened in Brackeen, where even the folks who wanted to say it's unconstitutional, like Alito and Thomas, couldn't agree on why. And I left oral arguments thinking that too, where there was definitely some skepticism, even from some of the people who joined the majority opinion. There was some skepticism or some questions that they asked that seemed hostile to ICWA oral arguments, but they were all coming from a different direction. So they couldn't coalesce a majority around that, which I think is, I don't know, it's interesting.
So this is a question for all 3 of you. And Steve, I'll start with you. We've had a lot of changes on the court over the last few years. We have 4 new justices in just the last 6 or 7 years. That's an enormous rate of change for an institution that doesn't really change that much. Do you think the sort of unexpected results we've seen this year are a sign of the court converging on maybe the ideological stances we can expect going forward? Or do you think we're in for a period of even further disruption?
Sure. I mean, keep in mind, we don't talk about this enough. The justices only decide the cases they want to decide. And so before the court even agrees to resolve a case, there has to be at least some convergence, because at least 4 of the justices have to agree that the case is worth taking. They're not going to hit 60 signed decisions in merits cases this term for the 4th term in a row. Before 2019, the last year that happened was 1864. So we're already talking about a pretty skewed data set of the justice's own creation. And within that data set, I think we're heading for more divergence. I think the fault lines are only going to grow because they're part of the same overall phenomenon here, which is a court that is, as unaccountable a court as we've seen really, I think, in its history, where, in prior moments in the court's history, if the court was believed or perceived to be, behaving in ways that were outside of its lanes, Congress had all kinds of levers it could and would pull to rein the court back in. We're not seeing that anymore, whether it's with regard to ethics or the merits docket or the shadow docket or the budget or anything about the court. And so, if you're a justice, what are your incentives to moderate, right? What are your incentives to be conciliatory if you're not looking over your shoulder at your colleagues or Congress? So, Matt, I think we're in for more of this, not less. Terms that are going to be sort of a bit weirder than last term, which was just such a wipeout for, a wipeout win for conservatives and loss for progressives. But I also think that we ought not lose sight of the fact that this is all the justice's own doing in the first place. And that, it's not like these cases are falling on them. These are the cases they are choosing to decide in a moment in time where only the conservatives can single-handedly put cases on the court's docket. The liberals can't. And so I think that suggests that we're in for more difficult and unpredictable behavior from the court, more messy coalitions, more weirdness, and all in the same direction of, an unaccountable court that ought to be reined in, but isn't being reined in for the near future.
Kirti?
I think I agree with the bottom line of we'll probably see more convergence for the reason that Steve gave, but I think it's particularly hard without knowing how the remaining 7 cases come down. But I think also one thing, at least I'll be looking for, is to see how the court composes its docket for next term. There are some cases that I think are big on the docket for next term. I'm not sure whether other people would, but there are also some classic, resolved circuit splits and sort of arcane statutes type cases. So I'll just be curious whether they fill up their docket with more of those or whether they keep taking some big swings. And I think, the other thing to think about, I guess, when you're looking at the court is whether, we have a decision like Moore versus Harper. I think if you read the mootness section of that opinion, it's a little hard to read that as the court not at least trying a little bit to get to the merits. And I suspect that the court knew it would get headlines like the one that Steve mentioned, that it's moderate or it's doing the right thing once it reached the merits and did what it did. So I do, I can't read their minds, but I do wonder if the fact that their approval rating is lower than it's ever been, at least is influencing their decisions a little bit. I don't think it's going to stop the justices from interpreting the law the way they think it should be interpreted at the end of the day, but I do think that it's definitely having some effects in how it's choosing to decide some of these cases.
And Rebecca, where do you think the court goes from here?
Ooh, that's a big question. I think if we're talking about the arena of federal Indian law, I think, unfortunately, we're kind of used to a court that has taken some very big swings. And often when it swings against tribal sovereignty, it's also not following its own precedent, not following the letter of the law, sometimes not really following, the Constitution. And so I think that that's something that has plagued Indigenous nations and has really harmed Indigenous rights in this country. And so I think sometimes there can be this misperception because sometimes, the victories like the Brackeen case or, the McGirt case a couple terms, it seems like recently those have been the cases that have sort of maybe gotten the most attention, and people are surprised that, Gorsuch is writing this way. And it seems like, oh, wow, like tribes have some kind of coalition on the court that other groups don't have. But it's not, it's not in every case, and it's not even right now in the majority of cases. So I think that, there's still a lot of work to do. Like I said before, just like there being like that depth of the understanding, and also, like was said before, a lot of tribal advocates, like the main thing they're trying to do is just keep the cases out of the court, and not, just that's how concerned people are about setbacks that could possibly come from the Supreme Court. And so, I think that these big questions of, how wedded to precedent, and also just sort of that separation of powers question of, these are these actually questions that it's the role of the Supreme Court to even decide, or are these questions that are more rightfully up to another branch of government? I think are big questions in the arena of federal Indian law, but are also just like really big questions for our democracy. And so we'll just have to see where it goes.
All right. Well, I'd like to thank all three of our panelists for joining us today. It was really enjoyable to talk to them. We could talk about this all day, but unfortunately we're out of time. Thank you also, the audience, for tuning in today. We really appreciate it as well. If you want to rewatch today's discussion or catch up on previous installments of this program, please check out the rest of them on TNR's YouTube page. We'll be back soon with another TNR Live. Please check your inboxes and stay tuned for more details. I'm Matt Ford, and see you soon.